Welcome to the O'Connor Elder Law channel. I'm your host, Melissa O'Connor. Today I wanted to talk to you about the priority of preference when naming a personal representative. I recently had a family come to my office. A loved one of theirs had passed away without a will, and they just didn't know what steps were they supposed to take next and who's supposed to serve as the personal representative anyway. And so I had the opportunity to guide them through that process. Essentially, Florida statutes provides a priority preference that can be used as a guide. Section 733.301 of the Florida statutes states that when a person passes away without a will and there's no personal representative therefore designated under the will, the surviving spouse has the first preference. They're the first priority preference. If the surviving spouse wishes to be the personal representative, they may serve as long as they're qualified to serve. The second preference goes to the person selected by the majority of the heirs. So if the heirs get together and decide that one person should serve as the personal representative and that person's willing and able to serve, then that's the personal representative, because that's the majority of the heirs agreed to that. If there's no agreement, then the third priority preference is the heir with the nearest degree and relationship. And if there's more than one person that has the same degree and relationship, the court will decide who is best fit to serve as the personal representative. So these are our guides. There's been case law that supports this. For instance, there was a case where a woman passed away. She left behind her husband and a daughter, a minor daughter, and her mother had petitioned to be the personal representative, and the court appointed the mother. And the husband appealed, saying, "Hey, I'm the surviving spouse." And the appellate court couldn't find any reason why the trial court wouldn't have allowed the husband to serve as the personal representative, and so they reversed the trial court's decision. So the priority preference is pretty clear, and it's established, and it functions really well. As long as the person with the most priority wishes to serve as the personal representative and they're otherwise qualified to, meaning they're a Florida resident, they're not a convicted felon, they don't have a mental or health capacity issue that would prevent them otherwise from serving, they may serve. And so that was helpful to the family to see that there was a guide in place, and I hope that it's helpful to you too. Feel free, if you appreciate this content, to like and share with others that you think would benefit from it. Thank you.